Hi, I'm Mark Palmer, and welcome to Reimagining Law. Today I'm joined by Trisha Rich. Trish is not only a commissioner with the Commission on Professionalism, but she is also a partner in the Holland and Knight's Chicago and New York offices, where much of her focus is on legal ethics and professional responsibility matters. We also have Melissa Smart. Melissa has spent over 20 years at the Illinois Registration and Disciplinary Commission, where she has served as their Director of Education. Melissa, Trish, thanks for joining me.
Thank you for having me.
Before we jump in, I'd like to invite our viewers to please like this video and follow us. Subscribe for new episodes coming up soon. You both bring great perspective, not only to the area of legal ethics for practicing law, what we must do, but also what we should do in delivering legal services. Trish, a term that's often used and comes directly from our preamble of rules on professional conduct is zealous advocate. What is the difference between being a zealous advocate for your clients and being overly aggressive?
Sure, Mark, thanks for bringing that question up. We talk about this a lot in the field of legal ethics and professional responsibility. We want and encourage and set the bar at the idea that we'll be zealous advocates for our clients. We will put forth meritorious arguments. We will show up. We will do things on time. We will do all of these things. But sometimes attorneys cross the line into being aggressive or overly zealous, I guess is maybe the nicer way to say it. And that can make things really difficult. It really can turn up the temperature on a matter. It can subvert the client's goals. And so riding that line and making sure that you're doing everything that you should be doing and need to be doing for your clients without being overly aggressive is something attorneys have to be mindful of.
And Melissa, when you see these cases, both on the tail end, but also as you educate lawyers throughout the state on the impact of this aggressive behavior on how they deliver services and how it affects the bottom line for the clients and their billing. What are those outcomes and how does it really impact the difference between being a zealous advocate and being overly aggressive?
Oh, well, unfortunately, Mark, from a regulatory perspective inside of this discussion, we often see the negative impact, and the negative impact can be great. Attorneys have reported that it makes matters more difficult to resolve when one side is being more aggressive than necessary, when they're, as Trish mentioned, going from zealous advocacy to aggressive advocacy. It also harms public confidence in the legal system and the judiciary, and it prolongs the conclusion of the case. So those are very pragmatic outcomes. But we also see situations in which it literally hurts the conclusion of a case, where it causes there to be motions to be filed unnecessarily, where a client will lose a case. The outcome will be negative to their financial interests because of aggression. And then, last but not least is the potential discipline of the attorney. I mean, they will face disciplinary charges if that aggressive tendency, as you and Trish mentioned, goes over the line and is overly aggressive and gets into being harassing or disrespectful or other incivil or uncivil behaviors.
And I want to emphasize the point, and I want to get both of your perspectives on this. We kind of default to this atmosphere of litigation, but is this also true in aspects of transactional matters for lawyers, Melissa?
Oh yeah, absolutely. We see this in all, facets of the law, where attorneys can cross that line into being overly aggressive. And I think that's where attorneys sometimes conflate the concepts. When someone is in a negotiation, not in a litigation context, they may think that engaging in an aggressive mannerisms or style might be advantageous to their client because that means that their client will get more money or have a more successful outcome. And I think that's where some lawyers get confused. But the reality is that if you are overly aggressive, it's never going to lead to a successful outcome for your client, or in some instances for you, because that type of behavior only prolongs the negotiation or other non-litigation contexts, as well as in litigation contexts.
Yeah. Trish, from the client's perspective, you being in a law firm setting, how do you see clients responding to overly aggressive attorneys? And also, what's the view from the bench that we see as well? How do judges respond to such attorneys?
Well, I'll start with your second question first, because I think that's the easier one to answer. Judges don't like this. Judges don't like seeing attorneys snipe at each other, either at the bench or in briefing or now over Zoom. It really is an unfortunate side effect of litigation sometimes. With respect to clients, sometimes they do like that, right? Sometimes clients are into having, a pit bull lawyer or a shark lawyer, or, you hear these terms, but that doesn't mean that it's good, right? And a smart client will realize that having a lawyer that's overly aggressive, lengthens the time of a case and drives costs up. And so a smart, savvy client will realize that that's not usually in their best interest.
Yeah. At the top of this discussion, I mentioned the differences between what we must do and should do, specifically addressing the rules of professional conduct, which all the states must adhere to their own versions. What about when an act or the behavior of an attorney doesn't quite reach the level of an ethical violation? Are there things, Melissa, that the ARDC is focusing on how to address those matters, either proactively or when they get maybe complaints from either clients or other lawyers or even judges about over-aggressiveness or incivility aspects that aren't technically a violation of a rule?
Certainly. And it's a great question. I mean, if you think about it, incivility issues and aggressiveness, it's a spectrum. And so obviously not all individual activity that could be considered incivil or aggressive is going to lead to disciplinary action. So what do we do, and what has the Supreme Court, equipped us with in order for us to deal with these types of situations? And the court has provided us with a lot of mechanisms. First, of course, is the educational component of things, where we can't stress enough the importance of outreach and just having conversations like this one. But also the court has implemented new rules that require all attorneys to complete certain number of hours of CLE credit in the area of professionalism, and now more recently in the areas of diversity and inclusion and mental health and substance abuse. And I'll take it one step further and argue that in a lot of cases of incivility or overly aggressive tendencies on the part of an attorney, there's an underlying issue that could be afoot. So I think it's important for us to deal with diversity and inclusion and mental health and substance abuse issues at that educational level. Of course, we also, from a disciplinary regulatory perspective, have new rules that help us. So some rules such as diversionary programs, intermediary intervention programs, or we will send someone out to talk to an attorney to try to intervene when we see a problem. And then, of course, probationary elements to even matters that are short of discipline, asking attorneys if they've gone to anger management counseling or they've sought redress for their issues elsewhere, if they've written a letter of apology. These are things that will help attorneys avoid the ultimate outcome of having a disciplinary consequence.
Yeah, excellent points, Melissa, on the multidisciplinary approach as we keep seeing that grow and grow in Illinois and beyond. Trish, let's go to you for the final thoughts. I want to hear from your perspective, seeing both as you serve as your professional role when you represent attorneys that have already found themselves in deep water, or internally at your firm as you proactively educate your attorneys across the world. How do you address these issues where it's not really a violation of a rule, but you're keeping them down the right path?
Sure. Well, one thing to not discount is that there are a number of court remedies here, right? So this is what leads to sanctions motions and all sorts of issues like that. So even if it doesn't arise to the level of a rule violation, you might be facing other kinds of things. But really, the thing that I tell lawyers when they come to me with a problem like this is there's a lot of currency both at the ARDC and at the courts in recognizing you did something wrong and apologizing. It is the first rule of holes. You stop digging. And so many times I think lawyers, and I think Melissa would agree with this, they have a tendency to defend that behavior instead of just saying they're sorry and seeing what they can do and thinking about how they can make sure that doesn't happen again. It's really, I think, a much better path in a lot of cases. just to say that you're sorry and try to do better next time.
Well, that's the perfect life lesson to leave us at, I believe. Thank you, Trish and Melissa, for joining me today.
Thank you, Mark.
Take care.
And to all of you, thank you for watching. Please like and share this video. Look for more videos coming up soon from the Commission on Professionalism. Thanks for watching and be well.